Welcome to the deep dive. You know, law often feels like these ancient, fixed rules, especially when you talk about land and safety duties.
It really does. And maybe the oldest rule is about what a landowner owes a trespasser. It's usually not much, protecting property rights first.
Right. But what happens when that old common law idea, which is like super minimal, just runs headfirst into a specific modern safety rule, like, say, a regulation that mandates putting up a fence?
That's the exact conflict we're diving into today. Which one gives way? We're looking at a situation where you have a statute saying, essentially, you must block access, clashing with common law saying you only have to avoid, willfully hurting trespassers.
Okay, so the classic legal standoff.
Exactly. And our goal today is to walk you through the tool courts use to sort this out. First, remember the basic negligence pieces: duty, breach, causation, and harm. The key doctrine here, the tool, is negligence per se, often called NPS.
MPS, right?
And what NPS does, potentially, is let a plaintiff nail down those first two elements, duty and breach, all at once, based on violating that statute.
Negligence per se. It sounds like, I don't know, a legal shortcut. What's the big advantage for a plaintiff if they establish MPS? Especially thinking about that standard of conduct.
Oh, it's a huge advantage, maybe the ultimate shortcut in these cases,
Uh,
because it shifts the whole focus.
How so?
Normally, a plaintiff has to argue the defendant was unreasonable, that whole reasonable person standard. It can be fuzzy, but if MPS applies, the court just adopts the statute's specific command as the required standard of conduct.
So the legislature already decided what's required.
Precisely. The debate about reasonableness is basically over. If the defendant broke that specific rule, boom, duty and breach are considered proven conclusively.
Wait, hang on. So you're saying one safety regulation could potentially wipe out centuries of common law about property rights? That seems like a pretty big deal, shifting power from courts to legislatures.
It is a big deal, but it's not automatic. It only works if the statute meets a very strict test. The plaintiff has to prove all four parts of the MPS rule.
Okay, so what's this mandatory four-part test? Lay it out for us.
Sure. First, the statute or regulation has to clearly define the required standard of conduct. No vagueness allowed.
Clarity first.
Second, the rule must have been intended to prevent the type of harm that actually happened. The kind of injury matters.
Got it. Intent and type of harm.
Third, the plaintiff has to be a member of the class of persons the statute was designed to protect. Who was the rule meant to keep safe?
Right. Protected person.
And fourth, the violation must have been the proximate cause of the injury. There has to be that direct link.
Clear standard, type of harm, protected class, and proximate cause. That does sound rigorous. Let's see how it works in practice. We should look at a specific and frankly tragic case, OGuin v. Bingham County. First off, what are the key facts we need to know?
Yeah, it's a very tough case. In 1999, two young brothers, Sean and Alex OGuin, were playing at the Bingham County landfill. It was closed at the time. Shockingly, it was right next to a school and an open field. They got in through an unlocked gate. While playing inside, a section of the pit wall, which was apparently very unstable, collapsed and killed them.
Oh, terrible. And critically, what was their legal status on the property?
That's key. The court had already determined that under common law, these children were considered trespassers.
Right. And based on that status, what was the initial legal hurdle their parents faced with a standard negligence claim?
Well, under traditional common law, the duty owed to trespassers is incredibly low. The county howdy only had to avoid willful or wanton acts, basically intentional harm or really extreme recklessness.
So just failing to fence the place wouldn't usually meet that high bar?
Exactly. Simple negligence, like leaving a gate unlocked, generally isn't willful or wanton. So their initial common law negligence claim was dismissed on summary judgment. They hadn't alleged that level of misconduct.
Okay, so that sets up the perfect test case for negligence per se. What was the core legal issue for the appellate court?
The main question was this: did the trial court get it wrong by saying that even if the OGuins could show NPS based on violated safety regulations requiring the site to be secured, it still didn't change that high willful or wanton standard owed to them as trespassers?
So does the statute, if NPS applies, override the common law trespasser rule?
That's the heart of it.
And what rule of law did the higher court use to figure this out? State the full rule again, the elements.
They applied the negligence per se doctrine directly to that question. Could the statutory duty replace the common law? One. And again, the rule required checking all four elements. One, was the standard clearly defined?
Okay.
Two, was the statute meant to prevent this type of harm?
Right.
Three, were the plaintiffs in the protected class? And 4 was the violation of proximate cause. All 4 had to be met for the statute to control.
Perfect. Now for the court's elemental analysis.
Yeah.
Let's walk through this step by step, just like you do on an exam.
Mm-hmm.
How did the court apply the first element, the standard clearly defined part?
This one was pretty straightforward for the court. There were specific Idaho state regulations and also federal ones, EPA rules, for municipal landfills.
And what did they say?
They explicitly required landfills to block access by unauthorized persons, and even more specifically, they mandated that the site shall be fenced or otherwise blocked to access when an attendant is not on duty.
Pretty clear instructions.
Very clear. And the facts showed the landfill was closed, no attendant was there, and the gate wasn't locked or blocked. So the standard was clear, and it was clearly violated. Conclusion on element 1, met.
Understood. Crystal clear rule, clearly broken. Okay, now for what you said is often the trickier part, the second element. Was the statute intended to prevent the type of harm that happened here, death from a collapsing pit wall?
Right, this is often where MPS claims stumble. Did the rule aim to prevent this kind of accident? The court dug into the legislative goals, noting the overall purpose was protection of human health. That's broad, though.
So how do they narrow it down?
They found a key piece of evidence in the EPA's technical manual that explained the reasons for these access rules.
The context. What did it reveal?
The manual listed specific hazards the rules were meant to address. Things like people getting hit by equipment they couldn't be seen, exposure to hazardous waste, and critically here, injuries related to earth-moving activities.
Earth-moving activities.
Yeah.
And the collapsing wall fits that.
Exactly. The OGuins died because an unstable, dangerously sloped pit wall gave way. The court saw that as directly related to the site's geology, the earth moving inherent in landfill operations. It wasn't just some random accident. It was a hazard linked to the nature of the site itself, the kind of hazard the access rule was meant to prevent people from encountering. So, conclusion on element 2, met.
That's a really important connection they made, linking the rule to the specific operational risks of a landfill. Okay, moving to the third element. Were the children, legally defined as trespassers, members of the protected class, the rule mentions prohibiting access for unauthorized vehicles and persons.
This is where the common law status and the statutory language really clashed. Common law says trespasser, minimal duty. But the statute says protect unauthorized persons.
So how did the court reconcile that?
They focused on the purpose of the rule requiring the site to be secured when no attendant was present. The court reasoned that this requirement wasn't about sorting out why someone might enter without permission. It was about preventing anyone unauthorized from facing the site's dangers.
So it didn't matter if they were dumping trash illegally or just kids playing.
Exactly. The regulation didn't make that distinction. It just said, keep unauthorized persons out for safety. Since the rule was meant to protect all such persons from the inherent hazards when the site was unattended, the children fell squarely within that protected class, despite their trespasser status under common law. Conclusion. Element 3 was met.
Wow, so the statute's definition essentially overrode the common law label for this specific purpose. Okay, finally, the fourth element. What about proximate cause? Did the court decide if the failure defense actually caused the deaths?
Well, proximate cause is ultimately a question for the jury. But at the summary judgment stage, the court just needed to see if there was enough evidence to even argue about it, basically.
And was there.
Yes. The OGuins had submitted an affidavit from an expert. It detailed how the lack of fencing was directly linked to the dangerous condition, the unstable slope that led to the collapse. That expert testimony was enough, the court said, to create a genuine dispute of fact. It couldn't be decided just on paper. It had to go to trial.
Got it. Enough evidence to let a jury decide the causation link. So, with all four elements potentially met, what was the court's ultimate conclusion? Did the statutory duty trump the common law standard?
Yes, that was the final holding. The district court made a mistake. The higher court concluded that when a specific safety statute clearly defines a standard of care, like these landfill regulations did, and all four NPS elements are satisfied, that statutory standard completely replaces the general common law duty.
So, no more willful or wanton standard needed.
Correct. To stick with the higher willful or wanton burden, even after finding the NPS elements met, would basically ignore the specific command from the legislature to fence the site for public health. So, the dismissal was reversed. The case could proceed to trial using the standard negligence framework based on the duty established by the regulation.
That's a powerful illustration of NPS in action. But let's test those boundaries, especially element 2, the type of harm, which you said is often the weak point. Let's try a hypothetical.
Okay, let's do it.
Suppose the 30 county again fails to fence the landfill. Clear violation. A teenager trespasses through the open gate. But instead of going near the pit, they find an old mattress someone dumped near the entrance, decide to bounce on it for fun, and whoops, they land wrong and break their ankle. Does negligence per se still apply?
Ah, that's a great hypo to test element too. In that case, NPAS would almost certainly fail. The plaintiff would likely be stuck back with that very minimal common law duty owed to a trespasser.
Why? The statute was still violated, right? The fence wasn't there?
True, the statute was violated. But remember element 2. Was the statute intended to prevent the type of harm that occurred? The OGuin court zeroed in on harms related to landfill operations equipment, waste exposure, unstable earth.
And breaking an ankle jumping on a random mattress doesn't fit that profile.
Probably not. That kind of injury, while unfortunate, isn't really related to the specific dangers the landfill fencing regulations were designed to mitigate. It's more of a general risk. You could find a discarded mattress anywhere. It doesn't stem from the unique hazards of earth moving or waste disposal that the EPA manual highlighted.
So the causal link isn't to this.
Precisely. The violation has to connect to the specific risk contemplated by the legislature or regulator.
Okay, this detailed breakdown is incredibly useful. So let's synthesize this for someone facing, say, an exam question involving a statute violation and an injury to someone on property, maybe a trespasser. What's the exam framework synthesis? Give us that step-by-step diagnostic checklist.
Absolutely. Having a structured approach is key to not jumping to conclusions or missing steps. Here's how you should tackle it.
All right, lay it out.
Step 1. First, always identify the injury and determine the baseline common law duty owed. Pin down the entrance status trespasser, licensee, invitee, because that sets your default standard. For a trespasser, that's almost always going to be just avoiding willful or wanton conduct.
Okay, step 1, baseline common law duty.
Step 2. Look for a statutory or regulatory violation. Is there a specific rule, law, or regulation that the defendant might have broken? Find it.
Step 2, find the break in statute.
Step 3. If you find a violation, then you engage the negligence per se analysis. Go through all 4 elements rigorously. Was the standard clear? Was this the intended type of harm? Was the plaintiff in the protected class? Was the violation approximate cause? You have to analyze each one.
Step 3, analyze all 4 NPS elements. Don't skip any.
Step 4. Here's the payoff. If and only if all 4 NPS elements are satisfied, then the statutory duty replaces the common law duty. Duty and breach under negligence are now established. That willful or wanton standard for trespassers, it's out the window for this case.
Step 4, if all 4 met, statutory duty replaces common law duty.
Step 5. Finally, complete your negligence analysis using that now established statutory standard. Address causation, actual and proximate if proximate wasn't fully resolved in Step 3, and damages.
Step 5, analyze causation and damages under the statutory standard. That's a really clear, actionable framework.
It helps keep the analysis organized under pressure.
Fantastic. So I think the essential takeaway for you, the listener, is really the potential power of a specific, targeted safety statute. It can completely shift the legal landscape, even overcoming really old, established common law ideas like the very limited duty landowners traditionally owed to trespassers.
It really highlights that shift. And maybe a final thought to leave you with is the inherent tension this creates, which OGuin illustrates so well. You have these kids, labeled trespassers, by centuries of property law focused on landowner rights.
Right.
But at the same time, they are clearly unauthorized persons that a modern safety regulation aimed at protecting human health from specific industrial dangers was explicitly written to protect. It forces us to ask, when the legislature makes a clear statement about protecting people from known serious hazards, how much weight should those older common law categories based on where someone steps continue to hold? That's a question the law is still grappling with.